Greetings and welcome to Habeas Corpus and Postconviction Remedies from American Jurisprudence. Liberty's last defense. The habeas corpus is the enduring safeguard of freedom. And this is going to be a very powerful presentation, so let's get started here. Before we do, though, just to remind everyone, this is strictly for the entertainment educational purposes of this YouTube channel, not to be used, misconstrued, mispurposed, or misused for anything legal, lawful, personal, private, business, tax, financial, or otherwise. So please don't do this at home. That said, let's get started here. And if you haven't already, please do hit the like to make sure we get the notifications out there and get as many people learning about these remedies as possible. There we go. Okay. So there's going to be a comprehensive overview of the American Jurisprudence, second edition, on habeas corpus and post-conviction remedies. So let's start with our introduction to habeas corpus. It's known as the Great Writ. It's a fundamental instrument for safeguarding individual freedom against arbitrary state action. So it's a very broad safeguard, you could say. Its primary purpose is to test the legality of a detention. The primary purpose, not the only purpose, but it's not for determining guilt or innocence. It's an immediate relief. It provides remedy for illegal confinement or unlawful custody. This has constitutional roots. It's protected by the U.S. Constitution, and it's rooted in English common law. The writ of habeas corpus is the most fundamental instrument for safeguarding individual freedom against arbitrary and lawless state action. So, very important. Let's continue. The origins of the habeas corpus. It started with the English common law roots, applied to several different kinds of writs under English statutory and common law traditions. It's a high prerogative writ, considered the vital remedy for obtaining immediate relief from illegal confinement. It has constitutional protection now. In the U.S. Constitution, it expressly prohibits the suspension of the writ. Article 1, Section 9, Clause 2. And early American adoption, recognized early in common law and preserved as fundamental safeguard of liberty. There is no higher duty than to maintain the writ of habeas corpus unimpaired. All right, we're on to understanding the habeas corpus. Habeas corpus is a generic term applied to several different kinds of writs in the American legal system. The most important is the writ of habeas corpus ad subjacendum, commonly known as the Great Writ. Well, you know what this means. We have to definitely take an excursion over here to Black's Law and figure out what that word means, because I didn't see it explained in the American Jurisprudence. So let's get right to it. We'll get to the S's. Takes a little while here. Once we're there, it'll move a lot quicker. This is a scanned document of Black's Law 9th edition. And we should be there soon, just as soon as it catches up. In the meantime, we can have some serendipitous definitions along the way here, while the screen jumps uncontrolled right now. All right, here we go. Now we're on the R's. So we're looking for, let's see what that word, subjacent, okay. Yeah, we'll get to this. Once we get that far, let's take another big jump here because we're still in the R's. And this is the SU's. Oh, secret session. Is there a secret squirrel session here too? Quarter session. All right. Let's jump a little quicker now. Now it's caught up with us so we can move faster. Let's get to the U's. jump a lot faster. All right. I passed it. Great. Bear with me here. We're almost there. All right. Getting close here. This doesn't even have, it has some keywords on the top here, but not many. All right, here we go. Subject, subjection. Should be getting close. Huh. Great, it's not there, huh? No, it's not. So it must be under habeas corpus. That's too bad. Yeah, no, it doesn't look like it's out of place either. Okay, that's all right. So we just jump up to the H's, and we'll get to habeas corpus. Somewhere around here. See if we get lucky. H, okay, around the I's. Nice. Okay, here we go. Still on the I's. We'll be getting the H's. An infant is also considered a minor, huh? All right. Thanks for bearing with me here. I'll edit this out from the final video, and I pass right by it. Here we go. Habeas. Yeah, I got to get a better scanning document for this. Here we go. Habeas corpus. All right, here he is. Habeas corpus ad subjiciendum. Ad subjiciendum. Ad subjiciendum. Okay. That you have the body to submit to. That's what that means. A writ directed to someone detaining another person and commanding that detainee be brought to the court, usually shortened to habeas corpus. All right. So here we have the pronunciations, which is good. We'll leave this open here so that we can refer to it as we go through these different types of habeas corpus. So it's a generic term, and there's different kinds. We have the ad subjiciendum. We have that's the great writ, the remedy for the illegal deprivation of liberty. See, this is very general here of liberty. They have the ad respondendum to remove the prisoner to higher court to prefer claim. Wow. So that's for responding. And then you have the ad satisficiendum to bring prisoner to superior court for execution. Yikes. And we have the ad prosequendum to remove prisoner for prosecution. The ad testificandum to remove prisoner to bear testimony. Wow, that's when they need to take him out, bring him into court to give testimony in a case. Cum causa to remove action from inferior to superior court. Wow, so these are different kinds of habeas corpus. While we're on to this, well, I'm glad you like the deep dive. Yeah, there's some special words here, but these are all yeah, Latin would have been a good one to take instead of German, I guess. But that said, let's get that off screen. There we go. We get the pronunciation and the definitions here, so let's just go over it right directly as it is. So the habeas corpus is the law, Latin, from you have the body. It's a writ employed to bring person before court, most frequently to ensure that the person's imprisonment or detention is not illegal. In addition, and that's the habeas corpus ad subjiciendum, In addition to being used to test the legality of an arrest or commitment, to test the legality of the arrest, the writ may be used to obtain judicial review of one, the regularity of the extradition process, which we'll be getting to, two, the right to or amount of bail, or three, the jurisdiction of a court that has imposed some criminal sentence, sometimes shortened to habeas, also termed writ of habeas corpus, the great writ. So let's see here. Oh boy. So from Black's Law, we have, make sure it's on screen, yes, the writ of habeas corpus, by which the legal authority under which a person may be detained can be challenged, is of immemorial antiquity. After a checkered career in which it was involved in the struggles between the common law courts and the courts of chancery and the Star Chamber, as well as conflicts between Parliament and the Crown, the protection of the writ was firmly written into English law by the Habeas Corpus Act of 1679. Today, it is said to be perhaps the most important writ known to the constitutional land of England. Charles Allen Wright, The Law of Federal Courts, that's where that's from. Okay, so we have the Habeas Corpus ad deliberandum et recipiendum. That's habeas. I should just read it from here. Habeas Corpus ad deliberandum ad deliberandum et recipiendum. I got it there. Okay, so now it should go a lot more smoothly after figuring this out, where those accents go. It's from the law in Latin that you have the body to consider and receive. Historically, it's a writ to remove a person from trial from one country to the country where the person allegedly committed the offense. Wow, that's also known as extradition. Wow, to remove, from trial. So habeas corpus ad deliberandum et recipiendum, and then the habeas corpus ad faciendum et recipiendum. Recipiendum. Wow, these are good. Recipiendum. Yeah, all right, there it is. Thank you. Habeas corpus ad faciendum et recipiendum. That's from Latin that you have the body to do and receive. In historic, it's a writ used in civil cases to remove the case and also the body of the defendant from an inferior court to a superior court, also termed habeas corpus cum causa. Okay, see certiorari. Then we have habeas corpus ad prosequendum. Habeas corpus ad prosequendum. That you have the body to prosecute. A writ used in criminal cases to bring before a court a prisoner to be tried on charges other than those for which the prisoner is currently being confined. Wow. And there's a habeas corpus ad respondendum. That's that you have the body to respond. It's a writ used in civil cases to remove a person from one court's custody into that of another court, in which the person may then be sued. Yeah. Then we have the habeas corpus ad satisfaciendum, and that's you have the body to make amends. In England, a writ used to bring a prisoner against whom a judgment has been entered to some superior court so that the plaintiff can proceed to execute that judgment. Wow. Then there's a habeas corpus ad subjiciendum, and that's when we've been talking about the great writ that you have the body to submit to. A writ directed to someone detaining another person and commanding that the detainee be brought to the court, usually shortened to habeas corpus. The habeas corpus ad testificandum. So the habeas corpus ad testificandum. That you have the body to testify. So this one's that you have the body to submit to. This one you have the body to testify. So this is to bring you before the court. This one is to have criminal cases to bring a prisoner to court to testify. Habeas corpus cum causa. See habeas corpus ad faciendum et recipiendum. Yeah, now I see why they call it cum causa. It's a lot easier than saying all that. Which is, again, a writ used to remove the case and also the body of the defendant from an inferior court to a superior court. Again, the certiorari, it says also to see. So we'll come back to the cum causa and the certiorari and see where we have any differences there. And I think that takes it to the end of the Black's Law digression. Let's get back to the text. More to it than he expected. Well, after we have gone through all this, now that we go through the American jurisprudence, we should be well versed in it. Yeah, show me the body before I remember it correctly. Well, we see here, it's a little bit deeper than that. Bring the body to submit to, bring the body to testify, bring the body from lower court to higher court, bring him over here so we could sue him, bring him over here so we could prosecute, or a judgment from another court, all kinds of different ways. So let's get back into it here. The habeas corpus is a generic term applied to several different kinds of writs in the American legal system. The most important is the writ of a habeas corpus ad sub justitiendum, commonly known as the Great Writ. The Great Writ, remedy for the illegal deprivation of liberty ad respondendum, to remove a prisoner to higher court to prefer claim. That ad satisfaciendum, to bring the prisoner to superior court for execution. The ad prosequendum, to remove prisoner for prosecution. The ad testificandum, to remove prisoner to bear testimony. And the cum causa, or the one that was more difficult to say with the et in there, to remove action from inferior to superior court. We'll stick with that. When used alone, habeas corpus typically refers to the writ of habeas corpus ad sub justitiendum. So that takes us to the habeas corpus ad sub justitiendum, the Great Writ, most important form of habeas corpus. Why? Because it grants immediate relief, primary remedy for persons illegally deprived of liberty. High prerogative writ. It's a vital purpose of obtaining immediate relief from the illegal confinement. It's a fundamental safeguard. It's an instrument for safeguarding individual freedom against arbitrary state action. And it's judicial scrutiny. It's a procedural device for subjecting restraints to judicial examination. The essence of a writ of habeas corpus is the immediate release of a party deprived of personal freedom. And now we're on to the additional habeas corpus writs. Now we take our test from what we just read in Black's. Ad respondendum, issued where one with a claim against a person in custody seeks to remove prisoner to prefer claim in a higher court. But this is not recognized in U.S. courts. Ad satisfaciendum, issued where prisoner has judgment against them and plaintiff wants to bring him to a superior court for execution, which is also not available in the United States. So we're on to the ad prosequendum, issued when necessary to remove a prisoner in order to prosecute them. That is recognized in American law. There's the ad testificandum, issued when necessary to remove a prisoner so they may bear testimony in court, and we've seen that in the American legal system. Deliberandum et recipiendum, issued to remove prisoner to be tried in the proper jurisdiction, which is available in American courts. And finally, the cum causa, unusual form issued where a person sued in inferior jurisdiction wants to remove action to superior court, and that is recognized by some U.S. courts. While many forms originated in English law, only certain types have been adopted and recognized in the American legal system. Okay, Which brings us to habeas corpus in the U.S. Constitution. The privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it. Yikes, and that's from Article 1, Section 9, Clause 2. Unless in cases of rebellion or invasion, the public safety may require it. Yikes. So we have here the express limitation. Only express limitation on governmental powers in original Constitution. There's a federal application that applies to federal government actions, not state actions. There's limited exceptions, suspension allowed only in cases of rebellion or invasion. And state constitutions. Most states have similar provisions in their constitutions. It reflects the founders' view of habeas corpus as an essential safeguard of liberty against arbitrary detention. All right, we're on to the suspension clause and its exceptions. So the privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it. So we have constitutional protection, only express limitation on governmental powers in original Constitution. Federal focus applies to federal government, not state actions. The historical context is in response to the English king's abuse of detention without trial, and the power to suspend. Authority lies with Congress, not the president. So, there's a suspension clause in a nutshell. It's a limited constitutional exception, only with rebellion, invasion, and the public safety requires it. So, let's proceed. Federal and state habeas corpus. Federal habeas corpus is governed by Article 1, Section 9 of the U.S. Constitution. It expressly prohibits suspension, except in rebellion or invasion. Regulated by federal statutes, 28 U.S.C. sections 2241 to 2255. Applies to federal prisoners and certain state prisoners. With state habeas corpus, it's not required by federal constitution. Most states have similar constitutional provisions, though. Governed by state constitutions and statutes, and some states forbid suspension absolutely, without exception, which is interesting there. Key distinctions: constitutional basis. The federal clause limits only government, not states. The historical development is that the states developed independent habeas traditions. And the modern application now is that different procedures and scope of review. So be aware of the jurisdiction that you're applying it to. So the purpose of habeas corpus. Test the legality of detention, not guilt or innocence. It's not an appellate review. It does not determine guilt or innocence of a prisoner. It's judicial scrutiny. It subjects executive, judicial, or private restraints to judicial examination. That's it. But it provides immediate relief, provides swift remedy for illegal confinement or unlawful custody, and a summary proceeding designed to be swift, flexible, and summary determination of claims. The great and central office of the writ of habeas corpus is to test the legality of a prisoner's current detention. All right, we're on to the habeas corpus as an extraordinary remedy. The extraordinary remedy for securing release. There's an extraordinary nature. Securing the release of persons restrained by liberty. There's a personal remedy concerned with liberty, not property rights. There's a collateral attack. It's not an appellate attack. It's proceeding for reviewing errors. This is strictly a collateral attack on the restraint of liberty without authority. And there's a writ of error. Brings up the body of the prisoner with cause of commitment. So, writ of error is what the remedy, the extraordinary remedy for securing release. It was done by an extraordinary nature. So there's a personal remedy. It's not about rights of property. It's about personal liberty rights. It's a collateral attack, so it's not a substitute for appeal. And writ of error. It brings up the body of the prisoner with a cause of commitment. So these are the, I guess you could say, the most important aspects of the habeas corpus for it to be accepted. So the habeas corpus provides a special and extraordinary legal remedy for illegal detention. Okay, now we get to the habeas corpus versus certiorari. This habeas corpus is a collateral attack on detention. The certiorari is a direct attack on judgment. So this is a side attack just on the detainment side, but the certiorari is a direct attack on a judgment. The habeas corpus reaches the body, but not the record. The certiorari reaches a record, but not the body. The habeas corpus tests legality of restraint, but the certiorari questions jurisdiction of lower court. The habeas corpus is an extraordinary remedy for immediate relief. However, the certiorari is an appellate remedy for legal errors. So, as we saw before, this isn't a collateral attack. This is an appellate attack on directly on the judgment. Our key distinctions: nature of attack, collateral versus direct, the scope of review, the body in the habeas corpus versus a record with the certiorari, and the primary purpose of the habeas is the release, and the certiorari is correction of the record. So the immediate and extraordinary remedy of the habeas corpus applies to the body, where the certiorari is focused on the record. So while we're at that, let's look at what the habeas corpus cannot do. It cannot recover fines. It cannot be used to challenge or recover monetary penalties imposed by a court. And it can't recover damages, not available for seeking compensation or monetary awards for wrongful detention. So this isn't the way of doing it for getting that. It wouldn't be the habeas. Habeas is strictly to get that body away from the unlawful or illegal detainment. Obtain injunctive relief cannot be used to compel government action or prohibit future conduct. So no injunctions with the habeas. And revised judgments cannot modify or overturn state court decisions or judgments. Habeas corpus is solely concerned with personal liberty and is not concerned with property rights. So let's get to interpreting some of these habeas corpus statutes. There's some that add to the efficiency of it. Some of the state statutes here are intended to add efficiency of the writ, not detract from it. We have some that are to prevent inoperability, designed to prevent writ from being rendered inoperative. As we heard, some states don't have a suspension clause. Liberal construction should receive liberal construction in favor of liberty of citizen. Common law principles does not preclude common law principles, okay, unless expressly stated. So the statutes do not preclude the common law principles unless they specifically say in the statute that they do. So that's a good thing to know too. If there's nothing specifically precluding the statutes from the common law principles, then you can still apply common law principles in interpreting a habeas corpus. So the habeas corpus law should receive liberal construction in disregard, if need be, of the technical language used. Wow. And should always be construed in favor of the liberty of the citizen. This is an important phrase right there. The habeas corpus law should receive a liberal construction and in disregard, if need be, of the technical language used. Wow. Where do you hear that? And should always be construed in favor of the liberty of the citizen. All right, we're on to the constitutional limits on suspension. Writ may not be abrogated or efficiency curtailed by legislative action. Constitutional protection. Prohibition against suspension means writ cannot be eliminated, as we saw there, except with the invasions and rebellions and things like that. Regulatory authority. Legislature may regulate procedure with respect to habeas corpus. And purpose limitations. It may regulate to some extent purposes for which writ may be used. Fundamental right. Regulations must not impair fundamental right to substantive remedy. And this is a long one here. There's legislative authority versus constitutional protection now. Let's look at this. There's permissible regulations, time limits for filing. You have procedures for hearings too. Those are the permissible regulations. The impermissible ones here are complete abolition of writ and rendering remedy ineffective. So there can be no legislative authority to do any of those kinds of things, but they can put time limits for filing and procedures for hearings. So keep that in mind. There's legislative authority for those. Permissible restrictions on habeas corpus. There's time limits. So these are permissible depending on your state. Statutes requiring petitions to be filed within specific time frames. Successive petitions. Laws prohibiting filing multiple filings of the same claim. That is permissible restriction, but by state statute. Procedural requirements. Reasonable procedural regulations governing filing and hearings. And standards of review. Heightened legal standard for granting relief. Courts uphold restrictions that regulate procedure, but strike down those that impair the fundamental right to the substantive remedy, which is to restore the liberty of the body. So here we go. Habeas corpus in times of crisis. Suspension only permitted in cases of rebellion or invasion. There's a historical debate. Can executive or military officers suspend the writ during emergencies? There's a constitutional authority. In absence of congressional action, writ cannot be denied, even in wartime. The judicial position is the power to suspend is exclusively a legislative function. So Congress. The modern context is suspension remains an extraordinary measure of last resort. So for our historical developments in 1863, there's congressional authorization. That was a Civil War. Congress authorized president to suspend privilege when public safety required it. And in 1941, World War II, right? Hawaii governor's action. Hawaii governor's suspension of the writ after attack authorized by Constitution and statute. And the reach of habeas corpus relief. We got this right in a minute here. Let's check over to the chat and see where we're at. Looks like we're all caught up. If anyone's still here, please definitely hit the like. I know this can seem kind of dry, but it's definitely a very powerful topic that everyone should be aware of. Criminal proceedings. Relief from restraints arising out of criminal convictions. So restraints arising out of criminal convictions. This is part of the reach of the habeas corpus. Civil restraints. Protection against unlawful civil confinement. Custody of minors. Used in cases involving improper custody of children and special populations. Applied to custody of diseased persons or those with mental impairments. Habeas corpus serves as a universal safeguard against unlawful detention across multiple contexts. Now we're back to the habeas corpus as a collateral attack. So here's our collateral attack explained. Habeas corpus challenges legality of detention. It reaches the body, but not the record. It tests the lawfulness of custody, not the conviction. The lawfulness of just the custody. Independent proceeding outside direct appeal. Now in the direct attack, we have a direct appeal reviews trial errors. It reaches the record, but not the body. It examines legal errors in proceedings. It's part of the standard appellate process. Habeas corpus is not an appellate proceeding for reviewing errors, but a collateral attack on the legality of detention. Key point there. It's not an appellate proceeding, but a collateral attack on the legality of the detention. The summary character of the habeas corpus. Proceedings must be summary in nature to be effectual. There's going to be a summary remedy, classified as a summary remedy in legal practice. So its sole purpose is having the person restrained produced before the judge. That's the sole purpose. Proceeding in rem, analogous to a proceeding in rem, focused on the person's status. So speedy inquiry, designed to provide a swift and efficient medium for judicial inquiry. The writ of habeas corpus, the primary instrument for safeguarding individual liberty against unlawful state action, is designed to provide a speedy and efficient medium for judicial inquiry. A speedy and efficient medium. So, who are the parties to the habeas corpus? Pretty simple. There's only two parties before the trial court: the petitioner, the person detained and seeking release from unlawful custody, and the custodian. This is the person or entity with authority over detention. Our sole question is, does custodian have authority to deprive petitioner of liberty? This is our sole question. So when it comes to a habeas corpus, this is the sole question. If you get to write one up, the sole question in your mind, however you fill in all the details, does the custodian have authority to deprive the petitioner of liberty? Authority. Custodian. Petitioner of liberty. The remedy. Release from custody. The only remedy, so you don't have to worry about what you're asking for. The only remedy available through habeas corpus is one of two ways: the absolute release, the complete freedom from custody without conditions, or a conditional release, freedom subject to specific terms or requirements. Habeas corpus lies to enforce a right of personal liberty. When that right is denied, the court can only act by releasing the individual. It can only act. So when right is denied, right, a right of personal liberty, when that right is denied, the court can only act by releasing the individual. What habeas corpus cannot do. We saw this one, I think, here. Yeah, we saw this one here. We get back to that. All right, so there's a duplicate slide there. Federal habeas corpus statutes. 28 U.S.C. 2241 to 2243. That's the custody petitions. So these are federal habeas corpus statutes, if federal prisoners. Power of the courts to grant writs to federal prisoners. There's 28 U.S.C. 2244 to 2250. This is for state prisoners, the second or successive petitions and time limitations. Yeah. 28 U.S.C. 2254 is state custody, grounds for granting relief to state prisoners. And 28 U.S.C. 2255 is federal custody, motion by federal prisoners to vacate sentence. So a little bit more technical in the legalese here for the federal statutes that apply to habeas corpus. Federal habeas corpus statutes govern court jurisdiction, procedural requirements, and standards for relief. But again, they are only what's allowed or permissible by the Constitution. Statutory substitutes for habeas corpus. So post-conviction relief acts as supplements or substitutes for habeas corpus. So there's 28 U.S.C. 2255 is a federal motion to vacate sentence, primary post-conviction remedy for federal prisoners. But the state statutes have state-specific post-conviction procedures. Example given here is the PCRA in Pennsylvania. So the Post-Conviction Relief Act in Pennsylvania would have state-specific post-conviction procedures. In many jurisdictions, the purpose of habeas corpus is now served by these post-conviction relief acts, the PCRAs. Bill Thomas says he's still listening. Not sure how much he can retain. Yeah, there's a lot to retain here, but there is a bit of repetition. Almost snuck in a duplicate slide there to make sure everyone's paying attention. But I can see this isn't the most exciting topic, but it's a very powerful one that people need to be aware of if they want to be able to enforce all the rights that they really have that are secured for them to use. And this is one of the ways to ensure that when things go really far south, that there is a remedy and a swift one at that. So in many jurisdictions, the purpose of habeas corpus is now served by the Post-Conviction Relief Acts. So look to your state for those and how much they align with the federal aspect of it or for the U.S. constitutional aspect of it. Okay, the writ of coram nobis, common law writ serving as a means of obtaining post-conviction relief. This is the Federal All Writs Act, available under 28 U.S.C. 1651 to persons no longer in custody, when available for persons suffering continual collateral consequences after release. Coram nobis serves as a safety valve when traditional habeas corpus is unavailable due to a release from custody. All right, so we want to keep everyone's attention. We're going to look up this coram nobis, because this is it here for the slide. So let's check out what coram nobis is in Black's Law. And that's going to be in the C's, way up here. Oh, look at this. Very close. And we'll edit this part out here. Come on. Cooling off period. Here we go. Oh, geez, just passed it. Get back here. Okay, so coram, these courts. Oh, geez, get into the court section. There's a lot of those. Boy, this thing goes fast. All right, here we go. We're on costs. Very close. Thanks for bearing with me here, but we'll cut this off. I'll edit this out of the final video. Oh, I saw it there. Coram, there it is. I forgot the rest of it now. Coram nobis. Coram. Maybe over here. Wait. Miss it here? Here it is. Coram nobis. Excellent. Coram nobis. Before us. It's a writ of error taken from a judgment of the King's Bench. Before us refers to the sovereign, in contrast to the writ coram nobis before you, vobis before you, which refers to any court other than the King's Bench, especially the Court of Common Pleas. 2. A writ of error directed to a court for review of its own judgment and predicated on the alleged errors of fact, also termed writ of error coram nobis, writ of coram nobis, misspelled. Well, there's a misspelled one of it for the uneducated, but we here like to stick with the correctly spelled ones. Okay, so there it is. Coram nobis, before us. Yeah, we get that part. It was the nobis, I forgot. That time we found no quorum. All right. So we have the coram nobis serves as a safety valve when traditional habeas corpus is unavailable due to a release from custody. So, okay. For persons suffering continuing collateral consequences after release. And the habeas corpus in contemporary practice. For federal prisoners, use 28 U.S.C. 2255 motions to challenge sentences and convictions. For state prisoners, seek federal review through 28 U.S.C. 2254 after exhausting state remedies. Wow. American jurisprudence has some pretty good practice tips, I gotta say. Military personnel. Members of armed forces may challenge custody after exhausting administrative relief. And then, of course, we had the war on terror applied to detainees at Guantanamo Bay and other military detention facilities. The landmark cases, here we go. We have the Hamdi versus Rumsfeld, established right to habeas corpus review for U.S. citizens designated as enemy combatants. Then we had the Wilson versus Dotson, affirmed habeas as an instrument to obtain release from unlawful confinement. And the Boumediene versus Bush, extended habeas rights to non-citizen detainees at Guantanamo Bay. So some key habeas corpus precedents. Bill Thompson says, I'm going to guess new court for a quorum notice. Yeah, we're not even done yet. You're going to have a really great understanding by the time we get to the end of this, but we're almost there, so stick with us here. Yeah, the quorum. All right, as we continue, we have some of the key precedents for the habeas corpus. So we have Ex parte Bowman from 1807, early recognition of habeas corpus as a fundamental remedy for illegal detention. Then we had the Ex parte Milligan in 1866, around the Civil Rights Act time, established that military tribunals cannot try civilians when civil courts are functioning. Then we have Stone versus Powell in 1976. Limited federal habeas review of Fourth Amendment claims when state provided full and fair hearing. Yikes. Then there is Felker versus Turpin, 1996. Upheld restrictions on successive habeas petitions under Anti-Terrorism and Effective Death Penalty Act. So the AEDPA is used to limit successive petitions. So if they turn down one, you can't keep doing them. So I guess this upheld those restrictions in Felker versus Turpin in 1996. Then you have INS versus St. Cyr in 2001, protected suspension clause rights for deportable aliens facing removal. Wow. And then the Boumediene versus Bush in 2008, extended habeas corpus rights to non-citizen detainees at Guantanamo Bay. These landmark cases have shaped the evolution of habeas corpus as a fundamental protection against unlawful detention. So, here are some contemporary developments in habeas corpus. The AEDPA impact established heightened standards for federal habeas review of state convictions. The PLRA Act says the Postconviction does not apply to habeas actions, preserving access to this fundamental remedy. War on Terror, extended to detainees at Guantanamo Bay and military facilities. So that's a good one there. Within the procedural evolution, growing emphasis on exhaustion requirements and procedural default, of course. And here's some key scholarly works. Fallon, Habeas Corpus Jurisdiction, Substantive Rights, and the War on Terror. Scholar here, the Habeas Corpus and the War on Terror, and Weatherby. Well, this is Schaller, Habeas Corpus and the War on Terror, and Weatherby, Looking for Comedy in the Habeas Corpus World. And that's comedy. So we're on to the enduring importance of habeas corpus. This should be taking us to the conclusion now. It's a cornerstone of personal liberty. It's a fundamental safeguard. It protects individual freedom against arbitrary state action. It has constitutional foundation. It's protected by the suspension clause. Without rebellion or invasion, it cannot be suspended, with limited exceptions. For public safety, of course. It tests legality. This is what it does. It tests legality. It examines the lawfulness of detention, not the guilt or innocence. And there are evolving remedies as contemplated by modern post-conviction relief acts. Habeas corpus remains the cornerstone the cornerstone of personal liberty, ensuring no person may be deprived of freedom without due process of law. And that takes us to the conclusion of habeas corpus and post-conviction remedies, liberty's last defense, and habeas corpus as the enduring safeguard of freedom. So for the few that were able to make it through this entire presentation, salute to you. And I hope everyone was able to find something important within this presentation that they can leave with and have a little bit better understanding of the importance of what the habeas corpus and a bit of its history too. And please hit the like on your way out if you haven't already. And I hope to see you all on the next one. Peace out.